Welcome to this Farrar's Building Personal Injury Case Law Update. I'm David Roderick and I specialise in personal injury and clinical negligence, acting for both claimants and defendants. The webinar should take about an hour. I just need to point out some housekeeping. There's a Q&A function on your screen. I'll use that to respond at the end if there's time. Due to the large number of cases that I want to look at, if we don't have time, I'm of course happy to follow up questions by email or telephone, and you'll have those details in the end slide. The slides and the webinar recording are also going to be available on request. So to describe the talk, it will be split into two parts. Firstly, I'm going to discuss the most recent cases which have developed general principles of tortious liability, and those are general principles that we most often see occurring in PI and negligence cases. And the cases of general application are going to address the following. Firstly, in terms of the duty of care and establishing that, the assumption of responsibility on the part of the defendant. And secondly, in relation to secondary victims, we'll look at proximity in time to the breach event. And then we'll discuss employers being fixed with liability through either a non-delegable duty or indirectly through vicarious liability. And in each of those areas in 2022, there were statements of the perhaps now settled position of the law, whereas the law had been fluctuating over the past few years. And then secondly, I'm going to go on and highlight some of the significant reported cases from 12 to 18 months ago in various personal injury practice areas. So as I said, over the past perhaps 5 years or so, and following the Supreme Court cases of Robinson and of Poole, a number of claimants have sought to establish a duty of care in a novel situation where they are asserting that the defendant has negligently failed to act and or that a defendant has assumed a responsibility to protect the claimant from harm. Now, those arguments have tended to be met by defendant applications for a strikeout or a summary judgment based on there being no reasonable grounds for bringing the claim. And in last year's liability webinar, I highlighted the first instance High Court decisions in those PI cases, principally injury claims against the police and local authorities exercising their care functions. And the Court of Appeal has now dealt with two of those most notable cases. Firstly, in Tindall, you might recall the facts of this case. The police attended at an accident that was caused by black ice, and that first accident had injured a driver, and that driver started to flag down some other traffic in order to warn them about the ice. When the police attended, they put out slow signs and they cleared away the accident debris, and they arranged an ambulance for the driver. They then left the scene. They removed their signs and left the black ice still present. So there was nothing left to warn the subsequent traffic of the black ice. And a second accident duly occurred, which caused a fatality. The claimant argued that the police had A, intervened and made matters worse by removing the first injured driver, and or B, that by the steps that the police took, they'd assumed a responsibility for the safety of subsequent motorists. And at first instance, Master McLeod didn't strike out the claim, holding that it wasn't bound to fail. But the Court of Appeal have allowed the appeal from that decision. And their reasoning very usefully summarises the duty of care authorities, but in particular, it carefully and clearly describes the applicable principles that apply when considering whether the police have assumed a responsibility to an individual so as to give rise to a duty of care to protect from harm from a third party. And it's a difficult task for a claimant to establish. Paragraph 54 of the judgment is where this is all set out. So in general, public authorities' duty is to avoid causing damage. It's not to prevent future damage due to causes for which it's not responsible. Generally, liability won't attach where the public authorities intervened, but ineffectually so. Knowledge of a danger isn't sufficient to give rise to a duty of care, and mere arrival of the public authority at the scene, even if there's an expectation that they will intervene, isn't sufficient to found a duty of care. And the fact that there had been an intervention in the past that might even have conferred a benefit on members of the public isn't of itself sufficient to give rise to a duty to act in that same way again. So applying those principles, in the case of Tindall, the transient intervention by the police, putting out a warning sign, sweeping up the debris from the road and then taking down their sign and leaving, was described as a paradigm example of a public authority responding ineffectually, failing to confer a benefit that might have resulted if they had acted more competently, but failing to take steps that might have prevented the harm, didn't actually make the matter suffered any worse. They merely left the road as they found it. And Tindall was applied and followed in the summer last year in the case of CJ and the Chief Constable of Wiltshire. That was a case where the police failed to properly investigate a report of indecent images. The negligence in that case was a negligent investigation that comprised failing to interview relevant witnesses, failing to send a computer for the proper analysis that was required. And so those aspects of negligence were a set of omissions, acting ineffectually, not making things better and protecting from harm by failing to do something, as opposed to a positive act which actually made matters worse. And that's the distinction that underlies the factual basis of the other Court of Appeal case, which we'll come on to look at. The slide there then summarises, therefore, that in terms of certainly public authority liability for personal injury claims in negligence, in particular against the police, is a relatively settled position. There would be fewer novel cases and fewer strikeout and summary judgment applications. So if we move to HXA and YXA, this was a successful appeal against the strikeout of a personal injury negligence claim against a local authority or two local authorities for failure to remove children into care after they suffered abuse. And the parameters concerning the assumption of a duty of care in local authority cases are much less settled and far more fact specific, and they remain an evolving area of law, because generally no duty of care will arise in respect of a social work function unless something more is done by the authority, which takes the authority's interaction with the individual child beyond that which the local authority is statutorily obliged to do. So the question is, how is that something more? And that's the language that's used in the cases. How's that something more to be described? How's it explained or exemplified? And as you can see on the quotation in the slide, I think it's from paragraph 105 of the judgment, this is an evolving area of the law. Full trials on the evidence will be needed for it to become clear where precisely that line is drawn. So novel cases and striking out of claims in local authority abuse, personal injury actions are much less likely, and striking out of the claims in HXA and YXA was incorrect. The next example of developments in the general principles of liability in personal injury is in respect of secondary victim claims, and in particular a point derived from the very well-known and important case last year of Paul and others, and it concerns the legal proximity test where negligence and a horrific event are separated in time. And we of course often not solely, but often encounter that in a clinical negligence scenario. As you'll recall, the claimants in Paul and the other cases, in each of those cases, they were claiming a right to recover for psychological damage in the absence of any physical injury, after they'd witnessed the horrific event that had resulted from clinical negligence. And the central point in each case was effectively that the horrific event that was witnessed and caused the psychiatric injury occurred a long time after the omission, which constituted the defendant's breach of duty in clinical negligence. And the stumbling block for the claims was that one of the mechanisms to control secondary victim claims, the mechanism set down by Alcock and developed by subsequent cases, principally Taylor and A. Novo. And the relevant mechanism in the instant cases was the requirement that the negligent breach needed to have caused an external traumatic event that immediately caused injury, and that proximity to the event or its aftermath in time and space meant proximity to the breach event, not the delayed consequences of the breach. And of course, those principles derive from cases where the negligence and the injury or the threatened injury that's perceived and creates the horrific event occur at the same time, or much the same time. And the question was about how the requirement for the claimant to be personally present at the scene or immediately in the vicinity and to witness an aftermath shortly afterwards was going to be interpreted in the context of a clinical negligence case. And the Master of the Rolls gave the leading judgment, and of course, firstly, the ratio of the decision is that the 5 elements in the control test are required in secondary victim cases, in clinical negligence cases, just as much as in accident cases. But it was also clearly expressed that looking at the matter without regard to the authorities, it's hard to see why the gap in time should affect a defendant's liability. And also, despite the fact that the horrific event in clinical negligence cases takes place later than a misdiagnosis, the fact and the consequence of the negligence is close in time and space to the moment when the secondary victim is caused the injury. However, the Court of Appeal was nevertheless compelled to answer a slightly different question. It's a question about the legal proximity between the defendant as a person and the claimant secondary victim, not the proximity between the fact and consequence of the negligence and the claimant's injury. And the case of A. Novo is binding authority for the proposition that no claim can be brought in respect of a psychiatric injury that's caused by a separate horrific event that's removed in time from the original negligence, whether that's accident, horrific event, or a misdiagnosis. And while there's no logical reason for those rules identified, that is how the Alcock elements have been built on, and it will take the Supreme Court to decide whether to depart from A. Novo effectively. And the Supreme Court is due to hear the appeal this year. Perhaps that situation, therefore, is ripe for a modification of control mechanisms. And I won't go into the details of the case, but a readily digestible summary applying the Court of Appeal decision in Paul, that a claim can't be brought in respect of psychiatric injury where there's a separate horrific event removed in time from the original negligence, was applied in the case of Kitchen and Hillingdon, again later on last year. That brings us to the third of the general principles to discuss, and that is liability that attaches through a non-delegable duty or attaches indirectly through the doctrine of vicarious liability. And both of those are doctrines that have had developments, significant developments over recent years. Both of the routes to liability just described were addressed in the case of Hughes and Rattan. So dealing with vicarious liability first, of course, there are two stages to consider. Stage one is whether there is an employment or an akin to employment relationship between the tortfeasor and the defendant. And stage two is whether there's a close connection between that relationship and the wrongful conduct that occurs. So the case of Hughes deals with stage one of that test. And the facts are that the negligence was on the part of self-employed dentists who all treated the claimant, all operating from the one defendant's dental practice. Now, on the one hand, these dentists decided when they wanted to work. They made their own clinical decisions. On the other hand, the practice took a percentage of their NHS tariffs, enforced various work policies on them, and set working hours. And so, weighing up those factors, were they independent contractors, which would prevent vicarious liability attaching, or not? And the question is plainly very fact sensitive in every case, but the High Court considered that the arrangement was sufficiently akin to employment to impose vicarious liability. But the decision this year in the Court of Appeals reversed that following Barclays Bank and various claimants, a case from 2020. And the Court of Appeal stated that if the question in Hughes had been only whether the treating dentists were providing their dental treatment to the claimant as an integral part of the defendant's practice, then vicarious liability might be upheld. But that now isn't the last word following Barclays. The critical question is effectively whether the relationship is analogous to employment, and the focus is on the contractual arrangements between the tortfeasor and the potential defendant. And here that test was simply not met for a number of reasons, principally that the treating dentists were free to work at the practice for as many or as a few hours as they wished, and they were free to work for other practices, other business owners, therefore no mutuality of obligation. Hughes and Rattan also dealt with, on the same facts, the claim for a direct liability on the basis of a non-delegable duty owed by the practice, and the decision of the High Court was affirmed by the Court of Appeal. There was such a duty. You'll recall that 5 criteria are required to found a non-delegable duty, and that's the case of Woodland. And the following were present and applicable in Hughes, and will probably translate into cases in relation to the private provision of healthcare services. So of some general application in the clinical setting, the claimant was in a position of vulnerability or dependency as a patient. There was an antecedent relationship every time the claimant signed a contract with the defendant's practice. Effectively, she entered the care of that practice. There was a positive duty on the clinician to protect from injury. That's by the very nature of being a clinical relationship. And the claimant was without any effective control in that relationship. The fifth element of the test being that there was a delegated function and it was performed negligently. So a translation across from that case into others where there's a similar sort of basic factual background, the clinical provision of private healthcare services. I'll also mention quickly a judgment that was very recently handed down, I think in late December, Carr and Brands. And this case deals with an array of particular issues relevant to employers' liability. But one of the points it deals with is the non-delegable duty of an employer exists even in the one-man band type scenario. The claimant in this case was a sole director and majority shareholder. I think his wife held a few shares. Effectively, he was the only employee of the defendant entity, and an independent contractor to that company performed a negligent inspection of a vehicle, which led to an injury causing catastrophic effects. And the otherwise non-delegable duty, which is pretty uncontroversial, that exists between an employer and employee, didn't cease to be just because the claimant was the majority owner, sole director, and sole employee of the defendant. And just completing the update, another Court of Appeal case in relation to vicarious liability again is the case of Chell and Tarmac. In Chell and Tarmac Cement, the Court of Appeal were dealing with the second stage of the vicarious liability test. You'll recall, that's the question: is there a close connection between that employment or akin to employment relationship and the wrongful conduct that occurs? The facts of this case were quite graphic. It's effectively a prank at work gone wrong, and an employee sets off an explosion next to a contractor and damages his hearing. In respect to vicarious liability, that would only attach if what the employee did was an unauthorised act that was connected with what he'd been authorised to do. That plainly wasn't the case, or it was an unlawful mode of doing something that was authorised. And the factors ruling out liability in this case, i.e. it not being an unlawful mode of something that was permitted, was that the pellet target, which was the explosive element that had been brought in, wasn't work equipment. Using such a target wasn't part of the claimant's work, and no activity that might use it advanced the respondent's business. It was in no sense within the field of the activities of the defendant. And I'll return to this case when we think about perhaps a breach of the direct employer's liability, which is also due to employees. That leads me to the second part of the talk and practice area updates. You'll see that the slide here provides neutral citations and also where the case law is reported for you to read them in full, if you are able to ever carve out the time to do so. But what I'm going to do is just attempt to mention the most salient points from each of them. Firstly, Brown and South West Lakes Trust and others. This is a case concerning the ambit of the duty under the Occupiers Liability Act 1984. And the decision focuses really on two things. What if any duty is owed to an unintentional trespasser? And how, or can and how do natural features of land perhaps form part of the state of the premises? And the facts of this case were the deceased's car accidentally veered off a highway and it fell down an embankment and through a wire fence and crashed into the reservoir, and regrettably the driver drowned. The claim against the occupiers of the reservoir was brought on the basis that there should have been better warnings on the road or the fence line, and there ought to be a more robust fencing line in place. And at first instance, the claim was struck out on the basis that there wasn't a danger due to the state of the reservoir premises. That's what's required by Section 1.1 of the 1984 Act. There wasn't such a danger because the reservoir wasn't defective in any way. It was just simply there. And the case was also dismissed on the basis that an occupier of land adjoining the highway didn't owe any duty to a motorist leaving the highway and coming onto the land. But on appeal, the claimants submitted it was arguable that there was in fact a danger that was due to the state of the premises, and that was the depth of the reservoir. That depth presented the risk of drowning to vehicles coming off the highway, and the occupiers had reasonable grounds to believe the danger existed. There had been reportedly one or two other incidents of cars coming through the fence. And so therefore the occupiers were on notice that use of the highway were in vicinity of this foreseeable danger. The claimants had to make an attempt to distinguish the well-known case of Tomlinson and Congleton You'll recall that's when a man dived into a shallow reservoir, and they did so on the basis that that was a voluntary act, whereas this was an entirely accidental, inadvertent exposure to the danger by coming off the road. Firstly, the Court of Appeal did accept that the statutory language, which is in both of the Occupier Liability Acts, of a danger due to the state of the premises, might properly include natural features of the land, simply the geography of natural features being there. But the Court of Appeal did rather firmly reject the claimant's other arguments, because the danger which might have been there due to the state, but might have been part of the state of the premises, didn't in fact arise from the state of the premises. The danger actually arose from the car leaving the road. And even if it had been arguable that the danger arose from the state of the premises, Lord Justice Dingemans, in that quote, paragraph 40, wasn't prepared to find that that would have been a risk in respect of which occupiers might reasonably be expected to afford protection. And again, translatable into cases based on other facts, there is nothing in the duties of occupiers with properties bordering a highway extending to preventing drivers from driving off the highway and onto their land. There is a claim in that case against the local authority for negligent construction of the highway, and that in fact was reinstated on the appeal. So it's also a watch this space in relation to the highway authority's negligence liability. Land adjoining a highway also featured in the case of Hoyle, and it's a case where a tree fell onto the carriageway, causing a fatality, and the claimant pursued both the highway authority and the arboriculturalist contractors. And it's useful for a local authority to consider. It discusses the standard and frequency of tree inspection regimes and the application of a Litho type test, what a responsible body of competent tree inspectors might or might not consider. On the facts, the claimant failed to establish identifiable defects in that particular tree, but it's useful for that general application that I've described. It's also useful briefly, perhaps an obvious point, but support to the fact that a tree on land adjoining the highway isn't part of the fabric of the highway and doesn't expose the local authority to liability for a failure to repair under section 41. The next claim, or next case we should look at is Occupiers Liability Act 1957 case, claim against a well-known retailer. And it's interesting, particularly useful for defendants in two respects. Firstly, it's useful for a defendant in relation to where there is a control aspect over premises that's sufficient to qualify as occupancy control under the Occupiers Liability Act. The extent of that control will be limited to the scope of the duty that's owed. And I can illustrate that through the relevant facts of the case. The car park in issue was owned and operated by the local authority. They took the money, they operated the barrier, but it was used by customers of John Lewis. And the claimant tripped on a high curb that was situated right alongside a disabled parking bay, and the height of the curb was in fact an unreasonable danger. It was determined at first instance for people who were disabled visitors. But nevertheless, the claim was dismissed at first instance, and the appeal upheld that dismissal because the trial judge was right to find that although John Lewis had control of a car park encompassing dealing with immediate hazards such as slipping risks and putting in place measures to deal with those types of hazards and reporting anything more serious back to the local authority, John Lewis's control didn't extend to painting a curb or to making a long-term structural change. Secondly, the case is also useful for a defendant because the occupier's control, although it extended to the ability to put up warning signs, which John Lewis hadn't done, Although that was something that their duty encompassed, however, the danger that a warning sign would have warned about was obvious. It was obvious in daylight. The visitor would be able to appreciate it, and the visitor would be free to do what was necessary for their own safety, to just step over a curb that was slightly high. So no warning was actually required, although control existed and a duty to warn of some risks existed within the control of John Lewis. So therefore there was no breach. So 2 points there. Aspect of control is qualified by the extent of the power you have as an occupier. So if you're fixed with occupancy status, it's not total, and warnings are not required for obvious risks. We move our focus to the Animals Act, and next are 2 Animals Act cases from the past year or so. Both demonstrate the significant challenges that claimants face in trying to establish strict liability. The first case, Ford and Seymour Williams, in particular, clarifies when strict liability will attach under Section 2.2. The circumstances involved a horse falling and crushing the claimant, and the horse rearing was suggested to be either caused by disobedience or a cardiovascular catastrophe within the horse. I set aside disobedience, which wasn't made out, and thinking about that cardiovascular event in the horse. The Animals Act can perhaps induce some of us, me certainly, to have to wrap a cold towel around my head sometimes, but the discrete point in this case was that in order to establish liability under Section 2.2, Section 2.2b requires that the damage that was done be due to characteristics that are not usually found in the animal, in this case in horses, or not normally found in the animal except at a particular time or in particular circumstances. And Section 2.2c requires that those characteristics are known to the keeper. Now, rearing due to a cardiovascular event didn't amount to the characteristic behaviour of horses on the expert evidence. So the focus of the case became whether it was necessary for the claimant to identify particular times, the particular times when, or the particular circumstances in which those characters arose in horses, and whether the act required the keeper of the horse to have knowledge of those very particular times and very particular circumstances. And the Court of Appeal surveyed the past cases in which a keeper has been held to be liable, and in each of those cases the court was able to identify that not only had the characteristic been particularly identified, but the particular times or the particular circumstances in which that characteristic behaviour had manifested. And so in each of the case, a particular event had been identified which had triggered the tortious behaviour, and the keeper had known that such an event could be a trigger. So to satisfy the requirements of Section 2.2, for strict liability to attach, it is going to be necessary to identify the characteristic. If you can't do that as a normal characteristic of the animal, identifying the particular time, when, or the circumstances in which, and the keeper's knowledge of the same is going to be necessary. And the next case is the case of Schultz and Ball, wherein a horse owner, again, wasn't liable under Section 2.2. The circumstances were that a horse had got loose from its paddock and wandered onto a motorway and collided with a taxi. Strict liability wasn't made out because the likelihood of the damage to the taxi passenger, or the likelihood of the damage being severe, wasn't due to the characteristics of that particular horse. They were not normally found in horses, except at particular times or in particular circumstances. So that was because horses are not normally in a mindless state of panic. and they don't normally ignore obstacles in their path. Such characteristics are usually only found in horses in circumstances when they're very seriously frightened. And on that, the claimant just simply failed on the facts. The evidence there suggested that the horse had in fact calmly walked from its field with an inadequate fence and onto the open road. Moving to employers' liability cases, and there have been a number of interesting personal injury decisions. Firstly, Chadwick and Ovenden, and it's in this case that the High Court has again usefully focused on the impact of the Enterprise and Regulatory Reform Act and Section 69 on common law negligence. And the court preferred and applied Cockerell and over the comments that we might recall from Tompkins and Tapp, and the court stated it's not correct to say that a breach of statutory duty under the health and safety regulations would ipso facto, the language using Tompkins, wouldn't ipso facto, wouldn't automatically constitute negligence. Section 69 removes that automatic link between a breach of the regulations and the right to claim damages. The case also contains a very useful and succinct description of what the common law duty does comprise. That's a section, paragraph 63. Reasonable steps are going to be situation specific and influenced by the particular work that's going to take place. The test has to be objective, and an employer is going to be in breach if a reasonable objective step hasn't even been thought about. And Lewin and Gray, the judgment came out about 2 weeks ago, was another attempt by a claimant to establish negligence as an automatic consequence of there being a breach of a health and safety at work regulation. And the factual background was a case where a self-employed builder had been asked to install some guttering on the fragile roof of a barn on a farm where he'd worked before. And the claimant's case was that the defendant owed the same specific duties in common law negligence as are specifically set out in the Construction Design Management Regulations 2015, and in particular Regulation 4, which refers to managing projects, and it requires the production of a construction phase plan. And the claimant's argument was built on a continuing potential criminal liability for breach of that regulation, and effectively breach of that duty, which was a failure to ensure that this plan had been completed, was admitted. And so the claimant therefore invited the court to find that the assessment of any common law liability had to start from the conclusion that the defendant hadn't met the standard of care that the criminal law requires, the QED. It was negligent. But the court determined that there was simply no justification for overriding what the clear effect of Section 69 of error provides for, absent the CDM regulations, absent the obligation within those regulations to produce a phased construction plan, a failure which in this case, in fact, hadn't actually been prosecuted. Absent that obligation, there's no justification for imposing such an obligation at common law, and in particular, on the facts of this case, on a person such as the defendant here, who was a man who ran a farm, and so technically it was a commercial construction project, but in most other respects, the reality of the situation was he was equivalent to a unsophisticated domestic type client. So the case is useful in relation to that specific argument, which we perhaps, acting for a defendant, might often encounter in relation to the residual criminal liability under the health and safety at work regulations. The case is also useful, and there was in fact, Occupiers Liability Act 1957 claim in this case, it's useful for defendants in OLA claims because the defendant also was able to rely on the statutory defence in the Occupiers Liability Act, that a person in the exercise of their calling should appreciate and guard against special risks ordinarily incident to it, and the fragile flat roof was one of those ordinarily incident risks for a roofer. And I'm returning now to the case of Carr and Brand, which I mentioned earlier, dealt with a number of relevant points. This is a sole employee, sole director company, and it also dealt with a specific employer's liability defence that was originally set out, the principles one can find in the case of Brumder. And it's where it's argued by a defendant that the sole employee and director is effectively the person who's at fault, meaning that the breaches of the company are the claimant's own fault. And that defence will only apply, A, where the act or the omission of the claimant has the legal result of putting the defendant in breach of statutory duty, but B, also only where the defendant employer can prove they've done all that they ought to have done to ensure compliance with statutory duties. And in Carr and Brand, the claimant, although there was a degree of fault on his behalf for not having a LOLA inspection, a lifting operations regulation inspection properly carried out, his fault was a world away from the total abrogation of responsibility in Brumder, the completely cavalier attitude to health and safety in that case. And so the claimant's own fault was not coextensive with the company's fault. And again, as I also mentioned, the case of Chell and Tarmac Cement is useful for detailing not just the vicarious liability test, which we've looked at, but whether also there's a direct breach of an employer's duty of care in circumstances where allegedly there's a failure to assess the risk of employee misconduct. Again, a category of cases which quite often we encounter. The factual background you have, there was a known ill feeling between employees and contractors on the site, and an employee brings in an explosive pellet and harms a contractor. And the claim was based on a direct breach of the employer's duty in relation to the control it had over its employees for a failure to risk assess the employee discontent. But that claim was also dismissed, even if there had been a foreseeable risk of injury that such a thing might occur. Even if that had been established, on the facts, the only relevant risk which an employer ought to have arguably have included in a risk assessment was the general risk of injury from horseplay. And it's a useful case of general application for the language the judgment uses, that common sense decrees horseplay is not appropriate at work, and it's unrealistic, it's unreasonable to expect an employer to have in place a system to ensure that employees don't engage in horseplay, at least in most circumstances. So those statements, I think, are likely to be of general use in employee misconduct cases. Briefly, I'll draw your attention to the following two cases. I'm conscious of the time moving on, but these cases both detail and deal with similar things, assessing risk in assault at work cases. And I think the first point to extract, principally from Cunningham and Rochdale, is for a claimant, certainly a very careful assessment of causation is always required. It's very commonly a significant threshold to surmount when you're running a case in relation to a failure to assess risk properly. Would it have made any difference? And similarly, it's a good line of defence for a defendant. In Cunningham and Rochdale, effectively, the claimant claimed that in an assault at work case, particularly in a school scenario, causation can be established where it's proved that the defendant was negligent, that there was some sort of breach, something wasn't done, and the loss of a kind likely to result from that negligence, likelihood of an assault, has then ensued. And the claimant submitted that negligence can be inferred from those two features, and that probability that the loss had been caused by the negligence would be established, even if the claimant couldn't say the precise mechanism is that you didn't do this, which would have prevented that. But that argument was rejected. The ordinary rules of causation will apply in those circumstances. And in the case of Hill, this principally concerns the reasonable foreseeability of injury in risky professions. And so Mr. Justice Cotter concluded that obviously there are some occupations where risk can't be wholly eradicated. The ordinary principles applicable to any type of occupation are applicable to inherently dangerous ones, and there's a duty to take reasonable care in assessing a baseline risk that's addressed within a safe system of work that has various parameters of levels of risk attached to it. For example, here, assessing prisoners where their characters, their volatility might vary. There isn't a duty to assess an enhanced risk in every case. I'll move the slides on now to RTA cases, and of course RTA cases are very highly fact specific. Over the past 12 months there haven't, in my view, really been a great deal of cases that establish novel liability points. However, the following cases have assessed the standard of care, and particularly the duty of a reasonable driver, what that should encompass in certain factual situations. And firstly, Parry and Johnson. We're all very familiar with cases that we describe as pedestrian stepping out cases. But this was paradoxically a case where the claimant stepped back off the road and onto the pavement. The claimant was walking down a dark country lane at dusk and was approached by a tractor which was towing a seeding machine, and the seeding machine overhung the verge that the claimant stepped up onto, and he was hit. And the case explicitly establishes, unsurprisingly perhaps, that a duty of care is owed to the pedestrian that remains on the pavement by a driver of a vehicle on the road. The duty extends geographically beyond the road ahead. And in that case, the court very strongly dismissed the defendant's assertion that there was some contributory negligence on the part of the claimant for failing to stay in the road just to make their presence more obvious. Again, that's perhaps an unsurprising finding. Vicarious and Bukowski is a case that illustrates the perils of smart motorways, but is of general application in relation to the standard of care when we're focused on modern and computerized and electronically controlled vehicles. Effectively, the management light on a car went out, and the defendant was able to drive it to an emergency refuge area. Turning over the ignition meant that the light went off, and the defendant then pulled away onto the motorway, but the engine failed, and there was a very significant collision. Effectively, a driver exercising reasonable care would have considered, the court found, that when the engine light cleared, when the vehicle apparently performs normally, the fault has apparently been resolved, a reasonably careful and competent driver wouldn't have anticipated further sudden failure. It wasn't unreasonable to rejoin the motorway in the case of a car that was a modern vehicle, properly and professionally maintained. In the case of, again, this is a recent case from December, Taylor and Raspin, and this is circumstances of an emerging vehicle. The defence, perhaps often run in these types of cases, is that the emerging vehicle will assert that the driver had become established, the vehicle had become established on the major road. And here, the driver had turned right out of a side road, onto a main road and into the path of the motorcyclist who is travelling along the main road in the opposite direction. So from the left, that's the second carriageway that the emerging driver would have entered. And the case is, again, unsurprisingly, a clear statement of the scope of duty of a reasonable driver, that a driver emerging from a minor road onto a major road obviously owes a continuing duty to all vehicles on that road in every lane. And how that duty is fulfilled will depend on the circumstances, but may well require a driver to look left for a second time before joining the far carriageway. Interestingly, in this case, there was further argument about the causative nature of the defendant's breach based on the speed of the approaching motorcyclist. And in connection to that, the court focused on the judge was arguably susceptible to some criticism because of the evidence, well, the emphasis he placed on the evidence that came from experts as opposed to the primary factual evidence, which consisted of people saying the driver could have stopped in time. And that statement perhaps helpfully leads us to the final recent cases to consider that I've gathered together really under the heading of assessing evidence. We can look really at a few PI cases over the past year that are of general application in respect of the forensic building blocks that will go towards establishing or otherwise rebutting liability in a PI case. And you'll be very familiar with the Court of Appeal upholding the findings of the High Court in the child running down case of Barrow and Merritt. The Court of Appeal found that there wasn't any merit in an appeal attack on the judge's decision that evidence of medical and accident experts wasn't determinative in that case. There were familiar submissions made and statements of principle in relation to the benefit of witness evidence and what to look for. Accounts given at a later time are not going to be as accurate as accounts at the time of an event. Honest witnesses might give inaccurate evidence. Memory can become subconsciously degraded, so it's not altered by dishonesty, but by a range of perhaps innocent biases. And the application of all those principles from the commercial cases translates across to road traffic accident cases, obviously. And a similar assessment of witness statement evidence is to be found in MUYEPA and the MOD, and this is a non-freezing cold injury case that the defendants defense to the case was it was very significantly exaggerated, or in fact it was dishonest, and that in fact the event bringing on non-freezing cold injury had been instigated by the claimant. In dismissing the claim on the basis that it was exaggerated to such an extent as to be fundamentally dishonest, the court reviewed approaches to be taken to assessing the veracity of lay witnesses. So useful to read in relation to that type of attack. Cross-examination is, of course, the gold standard of assessing a witness. Witness demeanour is instructive, but not to be given disproportionate weight. And I also highlight the case, perhaps a little in parentheses, because it's perhaps a point that goes to quantification rather than liability. But the court discussed the duties of expert witnesses, and in particular, criticised the approach and the partisanship of the care expert. Recommendations were made without adequately addressing any of the features that needed to be tied into the evidence, and so subjective and unreasoned opinion from a care expert heavily criticised. Finally, we come to the case of Carr, I think is probably the pronunciation. And in this case, which perhaps being followed with interest, the defendant served a witness statement from its solicitor analysing claims data in relation to a large number of claims that was submitted by the claimant solicitor's firm that were all very similar to the 5 claims in issue in these proceedings. And the vast majority of the claims contained allegations of psychological injury. All 370, the vast majority of them, contained that type of injury with a diagnosis of a recognised psychiatric condition having been caused, with strikingly similar recovery periods. And the defendant was able to suggest, on the basis of the analysis, that the figures showed really unusually high rates of an expert referring on further examination, and highly unusual long periods of recovery from a relatively minor injury. And the High Court has upheld the Circuit Judge's decision to allow that evidence to be admitted, despite there being some quite considerable concern that it wasn't purely factual evidence, that it might have statistical assumptions embedded in it that would require an expert to explain and to propound upon. But on the application to exclude that evidence, there wasn't any expert evidence. There wasn't any evidence about the embedded assumptions that would invalidate the defendant's survey and statistical analysis. There wasn't any evidence about that being invalidated as opposed to the evidential value being reduced. And so the decision of the High Court is that that evidence can be tested at trial if it ever comes to trial. So we have reached the hour mark, and that does conclude the slides. I should just look into I've got a Q&A, which is a kind comment. I don't have any other questions that have been put up. Thank you for the comment. It therefore probably just remains me to say that you've got the details on the screen there. You're very welcome to call or email me, and I'll discuss anything that we've looked at today. And as I said at the outset, if you wish to have these slides and access to the recording of the webinar, please contact Kelly Henderson-Smith in Chambers, and that will be facilitated for you. Otherwise, thank you very much indeed, and have a very good evening.